Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office with Attorney Codi Dada, founder of the Codi Dada Law Offices in Novato. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Lisa Mosbey, your host, and today we're looking at how long probate actually takes in California and what really determines whether a case moves efficiently or stretches out for longer than expected. Welcome back, Codi.
Thank you, Lisa. Nice to be here. Thank you very much.
Certainly. Codi, how long does probate typically take in California from start to finish?
Probate is notoriously known for being a very long process. On a good case, everything goes smoothly. You're looking at about 9 months. If things get complicated, there's conflicts. If heirs, legal beneficiaries aren't able to be located, it could drag on years, 18 months or more. So the problem is that the court wants things to be done a specific way. They're very rigid, and things have to fit into the mold of the court system. So if things aren't exactly the way they're supposed to be, then it takes time to find a way to make them fit the court's mold, generally speaking. And that's why probate is long process, like I said, 9 months to several years if it's a very large, complicated estate.
So, Codi, instead of thinking of it as one long process, um, how do we break it down over time into kind of a process?
Right. Yeah. And that's what we do for our clients to make it more manageable is we'll break it down into bite-sized pieces so they can understand what needs to be done. And then we'll coach them along the way as things come up. But basically, it's about 3 major steps. The first step is to get authorized. So you have to petition the court and get authorized to be the administrator. And what that requires is submitting a petition for probate and several other documents, putting a newspaper ad telling the world that this person's estate is going through probate, which allows any creditor or judgment, any interested party to have formal notice of the estate. So if there are people who are owed money, or if there's people that have conflicting interests, they have an opportunity to come into court and voice their complaints. Once the newspaper ad has been placed and all the legal heirs are notified, and then proof of service is filed with the court. That means that we have to tell the court that we've sent notice to all the legal beneficiaries called the legal heirs. These are the closest relatives and everyone named in the will. If there is no will, then we have to give all the legal heirs notice of the probate. And then we have to file what's called proof of publication, which the newspaper will send to the court telling them that the publication, the newspaper ad, has been placed for 3 times in certain intervals. Once that is done, then we go to the first hearing and they will approve the petition and grant a court order authorizing the person who's petitioned the court with the legal authority to manage the assets of the deceased person. And that's called letters of testamentary or letters of administration, depending on whether there was a will or no will. That's the first step. Then once the executor has that legal authority, then they have to pay all the bills, settle file the taxes, and make an inventory list of all the assets and settle all the financial obligations of the decedent. Once the inventory has been identified, we have to file an inventory and appraisal with the court probate referee. They call it a probate referee. But what that is basically it's an appraiser that works for the county, and their job is to give us a date of death value on all the estate assets. And we have to fill out an inventory and appraisal in a very precise manner. And if it's not filled out correctly, then the probate referee will reject it, send it back, and require us to fix it. But basically, once we send the probate referee a list of all the assets, that probate referee has up to 30 days to do an appraisal and give us a date of death value. Once we receive the date of death value, then we can move to the next step, presuming all the bills have been paid, all the taxes have been filed, and all final obligations have been settled. Once all that has been completed, then we have to file what's called a petition for final distribution. And with that, often requires an accounting. Now, there is a way where if all the beneficiaries of the estate agree, you can waive an accounting, which means that the executor doesn't have to formally create this very elaborate accounting that shows how much money came in, how much money was generated, how much money was paid out, and where everything went. And with that, the accounting has to balance to the penny. If things don't balance to the penny, then the court will reject it and require us to go back and fix it. So that is a hurdle in itself, because that requires hiring a fiduciary accountant. And that fiduciary accountant is very meticulous. They'll want every bank statement from every account from the month of death to the current date. They'll want every check stub, and they will enter that into this very elaborate system that will tell the court exactly what they want. Okay. Now, if all the beneficiaries or the legal heirs agree to waive the accounting, then we don't have to do that. But if just one of those people say that they want an accounting, then it doesn't matter if everyone else waived it. Then we have to create that and submit it with our petition. And that's really the last step of getting the money distributed, is we file a narrative report, and it tells the court everything that we've done. And we have to allege, they call it alleging, and you have to allege that you've paid all the bills, if you filed all the taxes, you paid the property taxes, you've paid the probate referee fees. Because remember, the probate referee gets paid a percentage of all the assets they appraise. So before we can even distribute the money to who it's supposed to go to, we have to pay everyone else. And once we've settled all the taxes and paid everyone else, and we've done everything we're supposed to, then the court will approve the petition for distribution. Once the petition for distribution is approved, we'll get an order from the judge that tells us exactly where to distribute the money, in what amounts, and to who. And then we will go ahead and do that. We'll go ahead and follow that order. And then once the money has been distributed, or simultaneously with that distribution, we'll ask each person to sign a receipt and an acknowledgement. And that person will sign off that says, yes, I've received what I'm supposed to receive, and I'm satisfied with everything. Once we receive the receipt and acknowledgement from each of the beneficiaries, then we file what's called a request for discharge. We have to go back to the court and show the court that we've given the money to everyone that's supposed to receive the money. We have to file the receipts that they've signed, and what's called an ex parte request for discharge, which is the executor asking the judge to be relieved of their duties as the administrator. Once that's been filed and all the receipts have been filed, the court will take a look at that, and if they're satisfied, they'll sign that, and that's when the process is finished. That's when the actual executor is off the hook and has no more legal obligations to do anything. So that in a nutshell is the basic process of probate.
That's not a nutshell, Cody. That's a month by month, step by step, long drawn out process. And I know you all try to make it simple.
It is the
Yeah, the other thing that I'm aware of is that each of those steps you listed can really cause a slowdown, waiting for the paperwork, waiting for the referee, waiting for the people, the members of the family to sign off. How do required waiting periods, like the creditor claim window, impact this overall timeline with all of the other activities that are happening?
Right, the creditor timeline, absolutely. So the law says that the creditors have up to 4 months from the date that the letters of testamentary were issued, or 60 days from the date that they were given notice of the probate, whichever is longer. So if these creditors come in many months later and claim that they were never given notice, then they have 60 days from the time they actually do receive notice to file a claim against the estate. And if they do file a claim against the estate, that becomes a requirement before the assets can be distributed. So before we can distribute the assets to who is supposed to receive the money, the beneficiaries, we have to settle those claims. So it's important that we give notice to all the known creditors as soon as possible. And that usually occurs in the first step when we send out notice to the beneficiaries. Included in that notice is the IRS and the Franchise Tax Board and the medical department that pays for that Medi-Cal and long-term nursing care and convalescent care. We give them notice, so if those entities are owed money from the estate, they can make their claim, or if they don't, within 60 days, they can no longer make a claim. They're barred from coming back and asking for money. Another thing that slows the process down is not knowing how to contact the beneficiaries. Oftentimes, especially when there's no will, then the law requires us to give notice to all the legal heirs. The legal heirs are your closest relatives. So that means it's your children. If there's no children, it goes to your parents. If your parents aren't alive, it goes to your brothers and sisters. If they're not alive, it goes to your nieces and nephews. So it becomes this process of locating people that we have no idea where they live. We have no idea if they're even alive, right? And now we're required to give them these legal documents. So if we don't give them these legal documents, the court won't approve the petition. So that becomes a huge challenge in itself, just trying to locate these legal heirs, which oftentimes requires using a air search company, which charge exuberant amounts of money to locate these people, or forensic accountants, or tracking down relatives and trying to get numbers of their, distant relatives. And it becomes this big, like, private investigation process. And sometimes they're never identified. And then at that point, we have to show the court that we've done our due diligence. So that means we have to show all the efforts that we've taken to try to identify these people. And only when the court agrees that we've tried hard enough will they let us continue without having to give that person notice. So it can get very, very complicated. Definitely. Whereas in a trust or yeah, see, that's why if you don't have a will, then we have to give many more people notice. But if you have a will, it still requires going through court, but at least the people that you've named in the will are usually closer to you, right? They're going to be able to be located a lot more easily than your legal heirs, which is very vague and could, lead us down to your siblings' children, and you may have not spoke with your sibling for decades, oftentimes, right? People get distant and they haven't contacted their siblings in decades, and they haven't talked to their nieces and nephews in decades, and they have no idea where they live or if they're even still alive. And now we have to figure that out before we can even move to the next level. See, so that's another reason why probate can take years.
I'm curious, what role does the court play in pacing the case to keep it moving?
Good question. Yeah, they do pace it. They want these things done. And so right when you get approved, they give you a series of court dates, and they'll say, this is your first court date. If you don't have your inventory filed, then they want you to come back to court and tell us why you haven't filed your inventory. Okay, so it's like a status report, kind of. And then they'll have another court date that says, if you haven't filed your final petition by this time, then you have to come back and tell us why you haven't filed your petition. You can't just, let it go and wait till you get it done. There's certain check-in points that the court imposes. And if you don't show up for those check-in points, or if you haven't already fulfilled that requirement, then the court can come in and remove you as the executor or charge you. They call it a surcharge. And they have the power to do what's necessary to make sure that the process continues diligently. Now, the court will allow continuances for good reasons. They understand things come up, conflicts arise, people can't be found, but they want to know what's going on. They're supervising it. So if there's a problem, you have to go let them know there's a problem. You just can't let it go and then, hope that they understand. You have to go in there and explain to them. And that's kind of how they make sure things are progressing.
Here's where I want to wrap this up today, Codi. For someone thinking ahead, before they're actually showing up for those initial court appearances, what steps actually make the biggest difference in avoiding these long timelines altogether?
Well, number one is avoiding probate, right? So with a trust, of course, so you're gonna have the people's names in there, and the trust will include their phone numbers, their emails, their mailing addresses, or at least their last known mailing addresses, and their relationship to you. So even if it's decades later, we can track them down. And we only have to track down the people that you've listed. It doesn't require us to give all your relatives notice like probate. It's just the people that are beneficiaries in the trust and successor trustees. So the trust avoids that by providing information in advance. Now, if you need to go to probate and you want to avoid these complications before they arise, then you're going to want to do your research and get the mailing addresses of the beneficiaries ahead of time. You'll want to go through the decedent's filing cabinet and get a list of all their identifiable debts, credit card statements, bank statements, mortgage statements, and try to have all the financial information in advance, so that way these court forms can be filled out without stalling and having to go back and search for these things.
Well said. I appreciate your insights today. I can see how it's a very expensive process, and our takeaway is definitely avoid probate. Get your stuff into a trust. I'm learning that lesson, and I'm hearing you loud and clear today, Codi. Thank you so much.
You're welcome. Thank you, Lisa.
Thank you for joining us for the Trust and Estate Clarity with Dada Law Office and Attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it. For more resources or to start your own plan today, visit dadalaw.com. Thank you so much for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.